Hello everyone, hello community of practice. Welcome to another webinar of the Climate Litigation Accelerator based here at NYU Law's Earth Rights Advocacy Clinic. As you may know, CLX is a global collaborative hub that catalyzes legal strategies, tools, and ideas needed to secure urgent and ambitious climate action. As a reminder of this, I wanted to let you know that our book, Litigating the Climate Emergency, is coming up. It's already been published in Spanish, and it will be published both in English and in Portuguese approximately within the coming month. So stay tuned. We'll definitely make sure to send you a message with the link to the book. In addition, another reminder is that we have our live website, the CLX Toolkit, where you can find a number of tools. This is a very much a dynamic website, so we definitely invite you, if you have any thoughts of tools that you think are necessary for your team, to please reach out to us, whether that's a short-term or a long-term process. We definitely want the website to be responsive to your needs, so let us know. So with that in mind, another thing that we try to do is to, in this very much fast-paced world of climate litigation and of climate action, is to respond quickly with analysis of things that are happening on the ground. So that being said, today we have this conversation where we will be discussing the Daniel, Billy, and others versus Australia case, more commonly known as the Torres Strait Islanders petition. For that, today we have our host, Cesar Rodriguez Garavito, which all of you know. And we also have an amazing guest, Hélène Triduja, who sits in the Human Rights Committee. Now, my job here today is to give you a little bit of background as to the case, so you have the main facts in mind as you hear this wonderful conversation, which we'll be listening to today. So, to give you some background, in 2019, a group of Torres Strait Islanders submitted a petition against the Australian government to the United Nations Human Rights Committee. As you may know, that's the body of independent experts that monitors the implementation of the International Covenant on Civil and Political Rights, the IPCC, by its state members. So some interesting facts about the petitioners is that they were all indigenous inhabitants of the low-lying islands of Australia's Torres Strait region. And interestingly, 6 of them were children. So the petitioners, in conjunction with their children, filed this petition. A lot of their claims and the primary basis of their claims surrounded the effect of climate change on their traditional lands and ecosystems. More specifically, they talked about how changes in weather patterns have direct impactful harms and consequences on their livelihood, their culture, and their traditional way of life. They claimed that Australia violated their rights by failing to sufficiently adapt to climate change. Some of the ways in which adaptation is talked about here is upgrading of seawalls on their islands, but also reducing greenhouse gas emissions. A lot of the claims especially focus on the spiritual connection between these indigenous peoples and their lands, and the dependence of their cultural integrity on the health of their surrounding ecosystems. This is, of course, as you know, and as we acknowledge, a very important petition, as it represents the first climate change legal action in Australia that makes an argument based on a violation of human rights. It was the first legal action brought by climate vulnerable inhabitants of low-lying islands states against a sovereign state. And it also continues to be the first legal action filed within a United Nations body by such people. So, of course, in August of 2020, so the year after the petition was filed, Australia asked the committee to dismiss the petition, not surprisingly. However, the committee did not listen to this, and about a month ago, on September 23rd, in what was truly a groundbreaking decision, the committee found that Australia's failure to adapt to climate change actually violated the indigenous people's petition, the rights. So more specifically, and I'm sure our conversation will get into this, some of the rights that were found to be violated are the right to culture, which is Article 27, the right to be free from arbitrary interference with privacy, family, and home, which is Article 17, and a minority of the committee also found Article 6, which is the right to life, to have been violated. The committee also stated that Australia must remedy its harm. So it stated that it must compensate the Indigenous islanders for the harm suffered, that it must engage in meaningful consultations with their communities to assess their needs, and finally, to take measures to secure the community's safe existence on their lands. So with that background, I will pass it on to our host, Cesar, and to our wonderful guest, Helen. Thank you very much.
Thank you, Melina, and welcome everyone. Thanks, Melina, who's, of course, one of our attorneys at CLX for that very helpful introduction and summary of the case. It's a pleasure to be with you all today. My name is Cesar Rodriguez Garavito. I'm a professor at NYU Law and the chair of the Center for Human Rights and Global Justice and the director of the Climate Litigation Accelerator. And it's a real pleasure to be with Hélène Diroudia today. She is not only a Human Rights Committee member, but she's also a distinguished professor at the Aix-Marseille, and we're lucky to have also as a Hauser Global Professor at NYU Law periodically. And we thought that we would bring together the community of practice and a global audience to discuss this important case that Melina described. And I just want to flag that this is a very rich case. Hélène has already very kindly also agreed to record the podcast with us. So for those of you who have followed the work of CLX and the Center for Human Rights and Global Justice, we're launching a new podcast under the umbrella of Open World Rights, which is an online opinion analysis portal that some of you may know about. So Hélène, the interview with Hélène that we did on audio and the analysis of the case will be the subject of the first podcast episode. So you will be getting an announcement about this through email. And today, what we want to do is engage in a kind of a fast-paced conversation with Hélène about the details of the case. Of course, we won't rehash the facts or the findings because Melina already summarized them, but we have the opportunity to have one of the committee members, a leading voice in the committee, to analyze, to go deeper into some of those issues. Also, we want to make sure that we leave time for the audience to ask questions. We're mindful that as the pandemic-related restrictions on in-person events ease, it's become less attractive to do webinars because we luckily now we get to do in-person events in most places. But what we don't get through a recording is the opportunity of the event. It's an opportunity to engage with the host and the guests. So that we will do definitely in the last 15 to 20 minutes of the session. So please do take advantage of that feature. You know how this works. Please post your questions in the Q&A chat box, and I'll get started by highlighting and working you all with Hélène through some of the key contributions of this case. So out of the, as Melina said, we at CLX have kept count. We have a database of all rights-based climate litigation cases around the world. And there, in our count, there are only 15 judicial or quasi-judicial complaints before international human rights organs, from the Human Rights Committee to the ongoing cases before the European Court of Human Rights, advisory opinion 2017 from the Inter-American Court of Human Rights. But this is the time, so it's not a huge universe, it's a growing, expanding universe of cases, but this is the first time that an international human rights organ finds violation of the Covenant on Civil and Political Rights in a climate change case, of course, and the committee is the quintessential interpreter of that covenant. And also, it's the first decision on the merits, because the Committee on the Rights of the Child last year, in a very important decision as well, stopped short of engaging with the merits because it found that the petitioners had not exhausted domestic remedies. So this is all to highlight the contribution of this case. So, Hélène, first of all, thanks for being with us today. Why don't we start with precisely where the Committee on the Rights of the Child left off on admissibility? How is it that the committee, in this particular case, found that the communication was admissible?
Thank you, Cesar, and first of all, thank you very much for organizing this space of discussion, both with academics and with practitioners, with students. And I have also seen in the list two special rapporteurs. So I think David and John that were also involved in the case because they were third-party interveners. So I'm sure they would have in the Q&A part input to bring into the conversation. So thank you very much for organizing this space. Even online, I think it's really a huge moment. So yeah, very briefly, and I will try not to be too technical, but you're right to start with the admissibility question, because in all these environmental cases, climate change cases, this is in general the main problem or the main issues. Here for this case, we had actually, I would say, 3 or 4 main problem of admissibility. The first one, it's not in the order, but the first one was about exhaustion of domestic remedy, because in this case, the authors of the communication have not used any remedy in Australia. So it's an obligation for authors who bring a case before the Human Rights Committee, and they have not used any remedy in Australia. So the state, of course, used this argument as a condition of, an element to reject the communication. The other, and I will say a word on our solution. The other problem of admissibility or question of admissibility was in relation with the question. And especially Australia said that the committee did not have material jurisdiction because it's a case on climate change. It's not a civil and political rights case. So the committee should declare non-admissible the communication for lack of ratione materiae jurisdiction. The third problem of admissibility, and I think Melina mentioned this at the beginning of her presentation, was the quality of victims, because we have many people, many members of community. They claim current violation, but also many future violation in relation with climate change. So Australia made the point that they have not quality of victims because they have not explained or they have not demonstrated a breach of the rights of the covenant. And the final point was about jurisdiction. Because of course, Australia said that climate change and global warming, it's a global phenomenon. So it's absolutely impossible to isolate the responsibility and the jurisdiction of only one state. So very briefly, the way we addressed all this admissibility question, there is one member and he wrote a dissenting opinion. But there is one member that consider that the claim should be declared non-admissible at all. I mean, considering all elements. But the majority of the committee was, I would say, quite convinced by the admissibility. On the exhaustion part, it was not the most complicated, I would say, because the authors quite well explained why they have not tried to raise any claim at the domestic level. They also brought in their file a sort of brief explaining how domestic remedies work in Australia and that it was absolutely impossible for them to use any avenues and so on. So it was quite convincing. On the ratione materiae point, it was also not very complicated actually, because yes, it's true that the background is about climate change, it's about global warming, Paris Agreement, and so on. But the authors also use provisions of the covenant and rights of the covenant, as Melina explained at the beginning. Quality of victims. It was a bit more complicated, because I have to say that the way the arguments were worded was sometimes a bit misleading, because many of the claims were about indeed future and quite broad violation or potential violation. So what we tried to do in reading the case was really to show also the current consequences and the direct and the really concrete consequences of climate change on the family life and private life of the authors. And for the jurisdiction thing, it was very different from the CRC cases. No problem of jurisdiction, because here we say that actually, especially for the adaptation measures, it was on the territory of Australia. So for us, there was absolutely no problem of jurisdiction. It was quite different. This question of jurisdiction was a bit different from, or was different from the CRC cases you mentioned. So that's why, I mean, we spent some time on the admissibility questions, but yeah, it was not the most complicated, I would say.
Thanks, Elaine. I want to press a little bit on the present versus future violations requirement, because it comes up consistently in climate change cases, of course, because most of the most serious effects will take place in the future, but many are taking place already in the present. And in 2016, in the Ethiopia versus New Zealand case, the committee decided that, or found that most of those harms will likely happen, if they do happen at all, coming from the sea level rise in Kiribati, in a Pacific Island nation, will happen 10, 15 or years into the future, but not now. Could you say a little bit more about how the committee concluded that in this particular case, in Billy and others, some of those harms were present as opposed to future?
Yeah, especially we could discuss separately, I would say, about the right to life, but it was especially on private life, family life, home on the one side, and cultural rights on the other side. It was more easy to find some current violations of rights, because especially in 2010, some of the authors suffered from destruction of their homes. So we had this, current and direct effect of climate change, because the home was destructed by flooding, and also they claim, and it was enough in terms of admissibility, they claim the destruction of their traditional way of life, destruction of marine resources, trees, fish, and so on. So everything that is really part of their family life and home. And I can go back on the merits, on the way we interpreted very broadly Article 17 on family life and home. But the broad element on these aspects of the way their life was already impacted and badly impacted by the consequences and the harmful consequences of climate change. So again, in terms of admissibility, for us, it was enough.
Mm-hmm. Great. I think that that's a great segue actually into the merits, because one of the striking things about the views decision is how creatively, but also how rigorously it interpreted Article 17 and in context of not just climate change situations, but also environmental situations, because this is not the first time that the committee decides a case on environmental harm, right? In 2019, the Cáceres versus Paraguay case, and last year, the Benito Olivera versus, and others versus Paraguay case on the impacts of pesticide use on indigenous communities already open the door for the interpretation of the covenant in the growing number of cases of environmental harm. So if you could speak a bit to that line of decisions and how the committee has interpreted the right to private life, family life, I think that everyone would be interested in that, because I also think it opens doors for interesting future litigation and advocacy.
Yeah, thank you. It's really something I would say that comes from a combination of regional jurisprudence, actually. So, and it's interesting because you mentioned, for instance, the advisory opinion of the Inter-American Court, but indeed in 2019, we started this broadened, I would say, interpretation of Article 17, family life, private life, and home, using the jurisprudence of the European Court of Human Rights, the jurisprudence of some other human rights organs. And the idea is to say that when we talk about private life, family life, it's and home, especially for a peasant community. So it was the case in the 2019 Cáceres versus Paraguay situation, or indigenous community in Benito Olivera of 2021, and this Billy and others. We cannot interpret in a Western way, I would say, home and family life and private life, but we have also, and it's really directly taken from the jurisprudence of the Inter-American Court, we have to also take into account the sort of cosmovision worldview of peasant community or indigenous community. So when we talk about home, it's not, it must be interpreted, I would say, culturally based, and with in mind the fact that home, it's also the spatial relationship with trees, with marine resources, and et cetera, et cetera. So we started in 2019 with a peasant community. So we used the UN Declaration also on the rights of peasants. Last year, in this other case versus Paraguay, we used the UN Declaration on rights of indigenous community and indigenous peoples. And also in this Billy and others, we continued, I would say, this jurisprudence and development of Article 17, and which for me it's good. I mean, again, the covenant was adopted in 1966 in a really Western way, with so it's good also to adapt the concept to other realities that maybe were not in mind of the drafters in 1966.
Thanks, Hélène. That sets up the stage for the discussion of the third right that was discussed, and both in the views and in the petition, which was the right to life. And this is where there was more disagreement and controversy inside the committee. So I think it would be important for us to discuss that part of the decision. So ultimately, the majority of the committee found that there was no evidence of a violation of the right to life, Article 6. But a number of concurring and partially dissenting opinions thought differently, and found that the committee members that wrote those opinions concluded that they would have found a violation of Article 6 on the right to life as well. I'm just going to quote a couple of sentences for one of those opinions, just so we hear this in the words of the committee or the minority of the committee itself. So in the joint opinion by committee members Buchan, Cran, and Sansin, I'm surely butchering the last names here, they concluded that in addition to a violation of Article 17 and 27, they would have also found a violation of right to life. And they said that they endorsed, and quoting, we endorse the view that integral to Article 6 is the right to live with dignity, which is something that the committee has said in the past. It is, however, critical to do more than simply reference the committee's jurisprudence. It must also be used progressively based on current realities. Moreover, it clarifies the direct connection between environmental harms, the right to life, and the right to live with dignity, and that state parties must duly consider the precautionary approach on climate change. Given the urgency and permanence of climate change, the need to adhere to the precautionary approach is imperative. So they conclude that the unfortunate outcome of this particular case is that the committee's jurisprudence promises far more than the majority delivers. So if you could speak to that lively debate inside the committee. Of course, it's not only the committee that has trouble applying the right to life to this mega collective action problem with climate change, but other bodies. So could you say a bit more about that?
Yeah, it was indeed the most discussed, I would say, part. Yeah, maybe with 27, but one of the most discussed part of the application of the communication on the merits. I was in the majority on that aspect, so I was not convinced by the claim on right to life with dignity, and I'm going to try to explain why as a member, but also the position of the majority. Maybe one point just to explain also where this right to live in dignity comes from. Actually, we have this in the general comment on the right to life that was for the first time expressed by the Human Rights Committee. So the general comment was adopted in 2018. And we have indeed a specific paragraph on states' obligation not only to protect against arbitrary deprivation of life, but also states' obligation to promote and to defend and to prevent violation of right to life with dignity. So in this case, in this specific case, my problem, I would say, or the reason why I was not fully convinced by the claim made on Article 6 is that actually it was really very similar and for me, much more captured by Article 27. Because actually in the complaint, the main claim on right to life is right to life as right to a specific way of life, and the authors constantly repeated this aspect that they have the right to a specific way of life under their traditions, their culture, and so on, which for me was much more captured by Article 27. That was my first hesitation, I would say, or reservation on the claim based on Article 6, and that would be a sort of repetition of or overlap of what we said on Article 27. The second element, and maybe for me it was also the most important, is that in the complaint, I go back to this question of quality of victims, actually, because in the complaint, they did not provide many information on, for instance, consequences on health, mental health, or physical health. And it's something that is quite different from the CRC cases. In the CRC cases, the authors tried to bring some elements, some evidence that the climate change had direct impact on their life and so on. In this case, it was really difficult to find it in the file and in the complaint. And maybe because we have practitioners, maybe the third element is that they used the jurisprudence, but the former jurisprudence of the Inter-American Court to try to how to say this, to try to achieve an outcome. And their point was to say that under Article 6, there is the right to live in a healthy environment. So they really clearly asked for the recognition of the right to a healthy environment connected to the right to life, as the Inter-American Court did in previous cases. But of course, we are in a different situation. So for me, there were a mix of arguments actually on the right to life. So I would be, in general, I'm quite open to this really constructive and creative interpretation of rights. But here I had the impression that there was a mix of different arguments under Article 6. And because it's really an important right, I would say for the first time, I was more in the cautious part of the committee. In general, I'm on the other side, but here I was not fully convinced, I have to say, as a member, but yeah.
Thanks, and that actually points to a very important issue for practice that we've discussed in these meetings, which is the need to document carefully the impacts of climate change on individuals and communities to strengthen the claims being advanced before domestic and international human rights bodies. And the fact that you refer to the CDC petition also brings up the issue of collaboration with scientists, for example, on evidence on mental health, which was done pretty competently in that particular filing. I'm not familiar, of course, with the initial petition, and we will have a closed door discussion about the petition in a moment. And I'm sure that the colleagues, the planners did a really good job on, well, the outcome helps us see how good of a job they did. But it would be important to see what kind of evidence was provided on this particular right. And also, I would encourage anyone in the audience or in the group to push further on this or on any other point. By the way, we have less than 10 minutes in this kind of a plenary, a moment of discussion, and then we'll turn to your questions. So please do start inputting those into the chat box here, into the Q&A box. The second issue where there was some disagreement among committee members, not as live and as widespread as on the issue of the right to life, was on the focus on adaptation as opposed to mitigation, right? Most of the filing actually, and also definitely most of the decision of the committee hinged on the lack of actions and policies on the part of the Australian government on adaptation, meaning the construction of sea walls to protect communities from sea level rise, the very slow pace of investing on adaptation measures to protect, again, the inhabitants of the Torres Island against the very pressing changes in their lives and livelihoods. However, the authors also mentioned the fact that Australia has not exactly have exemplary climate policies and is among, if not the largest per capita greenhouse gas emitter. So that there was a component of the communication about lack of action on mitigation and actually active contribution to worsening climate change as a global problem. And committee member Ziberi said that he would have liked to see the committee linking more clearly their findings to mitigation action or lack thereof on the part of the government, and not only the adaptation concept. So could you say a bit more about that and what you think about this objection?
Yeah, yeah. It was with right to life. It was the second main aspect, I would say, of the discussion. It's really based on the way the case was presented and pleaded, and also Ziberi made really a good point, especially at the end. Maybe I should have started with this, but made really a good point at the end of his concurring opinion. We are not very well equipped as a human rights body, actually, to address these sort of questions. So when we had this discussion and decided to split, indeed, some members, and I agree, said, yeah, but it's a bit artificial to split the adaptation measure and on the one side and mitigation action and the lack of active contribution and on the of the state in preventing and so on climate change. I agree, but if we would have considered the mitigation aspect, it would have opened really very difficult question of jurisdiction. And on this aspect, Australia really developed the question of jurisdiction. And some members said that on the mitigation part, it would be extremely difficult to prove and to establish the causal link between the lack of activity of Australia and the direct consequences on private life or traditional way of life. So maybe it was a way for us, because as you know, I mean, we adopt decisions by consensus. So it was a way for us because we didn't feel very comfortable in terms of proof and evidence on this mitigation aspect. So yeah, it was a way maybe not to address the main difficulties on this question of, again, causality and causation and jurisdiction.
Mm-hmm. Thanks, Len. So luckily we have plenty of questions from the group to get us started with the more interactive side of our conversation. John Knobs, who had to drop off early because he had to teach class, actually asked the same question about mitigation, and he was writing it as I was asking it. So I guess you've addressed it nicely, and that takes care of that particular issue, although of course it will come up again. This is such a pioneer decision that I'm sure that there will be other cases, and of course at the domestic level, most of the cases are being litigated on mitigation as opposed to adaptation. So this is kind of the flip side of that emphasis at the domestic level, and I would think that the committee is making an important contribution for judges and international quasi-judicial body members to committees and commissions to pay equal attention to adaptation as opposed to mitigation. Again, most of the cases, the best well-known cases, for instance, in Europe, have all of them have to do with mitigation. So this is an interesting counterpoint. Now, moving on to the questions. I would ask, I'll go with the ones that are kind of more specific and then go end with the broader ones. For example, Paul Rink is asking why the claim based on Article 21, rights of children, why was not addressed more explicitly in the committee's decision?
Yeah, it's another, I was about to talk about this, rights of children. It was not very substantiated. So that's I mean, we had a discussion in the committee whether or not we should declare non-admissible Article 24, because it was not, I mean, they mentioned the children as Melina said at the beginning, as part of the authors. So the claim was brought also on behalf of the children, but then it was not really substantiated in the communication. But for me, indeed, that was I would have loved to go further on 24. So on rights of children, because there is this intergenerational issue actually. But the majority was, I mean, I was in the majority, but the majority of the majority was not convinced on 24. But yeah, so we decided not to decide. So the bargaining among members was to say, okay, we declare admissible. And as Cesar said, it's really a sort of call for practitioners to bring next time more information, more legal reasoning. If you raise a provision of the covenant, you have to substantiate. So you have to explain very rigorously why, in this case, children are also victims of climate change. So we decided to at least open the door and to say, okay, it's admissible, but we decide not to decide. So it's not a satisfactory position, but it's also a way to say, again, to litigants, yeah, we may have a claim on this provision, but it has to be much more substantiated. But for me, I hope we will receive more on this intergenerational aspect of consequences of climate change.
Mm-hmm. Thanks, Elaine. So Ingrid Gubay is reminding us that the communication substantiated the argument about the exhaustion of domestic remedies, partly by saying and by quoting a decision by an Australian court, according to which the state doesn't owe a duty of care to regulate environmental harm in domestic jurisdiction, and that may have, although the committee doesn't quite say so, because it said, well, the state didn't substantiate its claim that there were domestic remedies available. Ingrid is wondering whether that has any implication for how the committee understands the type of remedy that needs to be available at domestic level for that particular admissibility requirement to be met.
Yeah, here it was, I would say, a sort of political decision of the committee, because, I mean, it was important for us also to send a message to state parties in terms of domestic remedies that should be effective and available for this type of claims. So it's true that there were some decisions, but we were a bit formalistic, and we said, yeah, they may have some avenues or some remedies for some aspects of the claims or some related questions, but actually on specific claims under private family life or claim under right to culture, there was no remedy. So we really had a quite strict interpretation of the kind of remedies that must be available for the authors in this sort of situation. So in indigenous community, in a very vulnerable situation, and with specific claims on culture and private life and family life and home. So, but indeed, I mean, we do not say, and the position of the committee is quite cautious, because we do not say there is no available remedies. We, at the admissibility part, we say that it's connected to the merits. So we will discuss this question later. And indeed, in the merits, we decide that there was no proper measures and so on. So we were a bit cautious in our assessment of what is available, what is not available, but it was enough for the admissibility stage.
Mm-hmm. And David Boyd, of course, the UN Special Rapporteur on the Environment and Human Rights, It's asking a question that I actually am so glad that came up, because I also had that question as I read the decision. He's saying the majority accepted Australia's submission on intervening acts that Australia might take in the next 10, 15 years. Given 30 years of inadequate action and the human rights principle of prevention, why is the committee taking this differential approach?
Yeah, that's a hi, David. That was also something discussed, and I think I do not remember if it's in one of the partially dissenting opinion, but one or two members say that maybe we should have adopted a different test, especially when dealing with the right to life, a different test to assess Australian actions or inaction, and especially prevention, and it's the principle of prevention. And I think, yeah, I think one member mentioned this in the opinions. But even with the principle, I agree with you, but even if we apply in this case the principle of prevention of violation of the right to life, the test applied by the Human Rights Committee to conclude to a violation of Article 6, it's really with a very high threshold. So in order to conclude to the violation of the obligation to prevent, the risk must be immediate, must be direct, and so on. So I mean, it's not, it's true that this 10, 15 period of time may be discussed, but yeah, the risk assessment, I do not think that in this case would have been that different than in the Tetiota case, for instance. So even with the principle of prevention, I do not think that the solution would have been different. Again, based on the way we interpret, in general, states' mission to prevent violation of the right to life.
Mm-hmm.
But maybe we have to change, and that's the interest also of this kind of cases.
Yeah, and also it may vary through time, right? As this is kind of a paradoxical, even sad aspect of time-dependent jurisprudence, because of course courts and international human rights bodies need to take into account how serious the current situation is. But by concluding that the situation is not that bad yet, then A, it sounds a bit cruel, and B, it kind of puts the decision on a timer, meaning that if a similar situation came to the committee or to another court in the future, then the decision might be very different, because the situation may have gotten much worse. So there's that tension between what should be done now as opposed to what can be deferred to the future, but knowing that in climate action, delays are costly, that future action is much more costly, both socially and economically, that present action. That whole jurisprudential line is quite, it's quite fragmentations, and that's one of the things that, of course, human rights as a whole is not exactly well designed to do, with to deal with future harms and time-dependent phenomena, which is actually what Verena is asking about here, saying, Verena Call is saying that because it's hard for human rights committees or human rights bodies and human rights norms to deal with future harms as opposed to current harms. Whether, and this is a more speculative question, not anything having to do with the specific decision of the committee, whether something like a new right to climate protection could better cover the future harm of the consequences of the very serious apocalyptic proportion consequences of climate change in the future. So just leaving aside for a moment the decision, is there anything that you wish human rights could incorporate as a tool, as a doctrine, that could make this type of case easier to deal with? Because now you're working with a 70-year-old almost framework to deal with consequences and to issues that no one ever thought about back then in the mid-1960s.
Yeah. Yeah, maybe I go back to the question raised by David precisely, because as human rights bodies, we work with our human rights tools and human rights vocabulary and human rights instruments. But of course, for experts in environment and climate change, for instance, principle of precaution and principle of prevention may have a different meaning. So the Human Rights Committee and other committees like the Committee on Economic, Social and Cultural Rights and so on, maybe have to think differently about many of the key concepts they constantly use for instance, this question of prevention, state responsibility, and that's also the consequence and the positive consequence, I would say, of that kind of cases. Cesar, I think I have lost you. Yeah. Okay. Yeah.
Thanks.
You are back.
Yeah. Sorry, I had some.
Yeah. So maybe that's we really have to to adapt, I would say, when you talk about climate emergency. To a certain extent, I was rereading the case, and especially in one paragraph, I think it's paragraph 8.7, when we say, I agree, we say that there is no violation of the right to life, but also we refer to very specific measures Australia committed to adopt in 2021, in 2022, in 2023. So it's also a way we use to send a sort of message and say, okay, in this case, we decide that the majority decided that there is no violation of six, but in the meantime, we recognize the emergency. But I agree with you, and that's again, that sometimes, and even if we go beyond the climate change questions, that's sometimes what I have in mind when we receive very interesting and innovative cases, but we have limitations. And we have limitations, and they're really, in terms of procedure and so on, there are things we cannot decide, or we cannot properly decide. And I would say exactly the same, for instance, on cases that are arriving before the Human Rights Committee, but also other human rights organs in relation with armed conflict. We are not equipped. We are not properly equipped to address some questions. But maybe, and that's, I finish with this, we need also, because they are practitioners, we need also to be educated. And that's the interest of third-party interventions, because some of us have a background on environmental law, climate change, or other, other human rights issues or other international matters. But we need to be educated, and we really, so that's the interest of third-party intervention, but also of this kind of open conversation.
Mm-hmm. Some final batch of questions. Sorry that I'm going to have to fuse a few of them into one. Have to do with the future, right? So what the future consequences of this particular decision might be on the committee itself and on international domestic law on climate change and human rights. So one thing one can anticipate is that there will be some incentives for people to take additional cases, additional communications to the committee. But of course, the committee is just one piece, and very important piece of a whole international architecture. So how do you see this decision affecting other forms of international human rights advocacy and litigation having to do with climate change? And if you know, what would be your wish for how this decision might contribute to that broader task, knowing that the committee can only do so much?
Yeah, very briefly. So I really do not know how the European Court of Human Rights will consider or not the decision of the Human Rights Committee. The European Court is not always consistent in using or not the decision of treaty bodies. Recently saw this with repatriation of children cases. Good decision from CRC, not that good decision from the European Court of Human Rights. So I cannot take for granted that the European Court will use any of what we have said on Billy and others. What is interesting maybe is for our committee, we have not registered new communications, I have to say. So I do not know if it's gonna be something quite common or regular before the Human Rights Committee. I would love, but we have not registered yet anything new. But what is interesting is that now when we have dialogues with state, climate change question is really regularly raised in the conversation. So it's a good point because we do not consider anymore. There are some members that consider this, but the majority of the committee does not consider anymore that climate change, it's not our business because it's an economic, social, and cultural aspect. So we are focused on civil and political rights. So the very positive element for me is really in favor of this sort of reconciliation between civil and political rights and economic, social, and cultural rights. And we are bringing again in the conversation with states this question of protection of environment, and it's really clear that the separation, the distinction of both categories of rights is purely artificial. So I think it's really a good element. The other good element I see is that there is an interesting and very positive competition between treaty bodies. So I hope that the CRC now will try to do better than the committee on the Human Rights Committee, and maybe our colleagues from Committee on Economic, Social, and Cultural Rights, and perhaps in the conversation there was a question of the colonial aspect. Perhaps our colleagues from Committee on the Elimination of Racial Discrimination would also try to engage the conversation, because there are a lot to say about the discriminatory impact of climate change, and some communities are more impacted than others. So there would be very interesting cases also to bring before CERT. So I hope they would have this positive competition. And of course, if we have the advisory opinion of the ICG, I really hope Billy and others will also be considered by the International Court of Justice. Let's see.
Thank you so much, Elena. Let's hope so. And thank you for engaging so candidly and also so rigorously as always with all the questions, and for also recording the audio responses that we'll be publishing as a podcast. Again, we'll be circulating information about the upcoming podcast. It will be out by the end of the month. And this recording, as always, will be available on CHRDJ's and CLX's sites. And this is actually, it's been so interesting, and thank you all, to you all for all the questions. I'm sorry that, well, we got almost to all of them, but in the future, we'll continue to endeavor to try to address them all at least briefly. And this event today actually kind of gave us very good ideas about how to run future events and more interactively, and also more open to engagement with the audience, which is, again, as I said at the beginning, a bonus for those who get to attend live, as opposed to those who have to watch the recording. So thanks again, Lynn. And for those of you who are part of the community of practice, as Melina put in the announced in the chat, box here, there will be a closed door half-an-hour debriefing, more with a view to learning from this case and from the strategy of the legal representatives of the authors. So stay tuned for the next webinar, and for those of you on the community practice, I'll see you on the other end in the separate Zoom link. Thanks again, Elaine, and have a great session at the committee and the rest of the day as well.
Thank you. Thank you.
Bye-bye.
Bye-bye. Bye.